4 years ago, a single Supreme Court ruling didn't just change one state's gun permit system, it kicked off a legal chain reaction that's still actively reshaping gun laws in courtrooms across the country right now today, in 2026. If you felt like gun rights news has been relentless for the past several years, one ruling after another, some expanding rights, some restricting them, some getting reversed on appeal, all of it traces back to a single 2022 decision called New York State Rifle and Pistol Association versus Bruen. Most coverage of any individual gun rights ruling treats it as a standalone story, a single case with a single outcome, when in reality, almost none of these rulings exist in isolation. Each one is a direct descendant of the same foundational methodology the court established back in June of 2022. I'm going to walk you through exactly what's happened since that ruling came down, state by state, case by case, so you understand not just what Bruen said, but the entire chain of consequences it set off, right up through the rulings that came down just this past summer. Before we get into the timeline, if you want to actually follow the full arc of how one Supreme Court case reshapes an entire area of law over years, not just catch isolated headlines without the connecting thread, subscribe and turn on notifications right now. Bruen is the best example in a generation of how one ruling's effects keep unfolding for years, and understanding the full chain matters if you want to actually predict where this area of law goes next, rather than being surprised by every new development as it happens. Let's get into exactly what's happened since June of 2022. Here is the one-sentence version of what Bruen actually did, before we trace everything that followed from it. In June of 2022, the Supreme Court ruled that Second Amendment cases have to be decided using history alone, meaning the government can only justify a modern gun law by pointing to a comparable historical regulation from the founding era or the Reconstruction era, rather than by arguing the law serves an important modern public safety interest. That single methodological shift set off everything that's happened since, because it meant literally every gun law on the books in the entire country, thousands of statutes across 50 states plus federal law, suddenly had to be reevaluated under a completely different legal standard than the one that had governed for the previous decade and a half. The first segment of the timeline is the immediate aftermath, the months right after the ruling came down. States with discretionary may issue permit systems similar to New York's original law, including California, Hawaii, Maryland, Massachusetts, and New Jersey, had to respond almost immediately, since their existing frameworks were directly incompatible with what Bruen required. Some states moved to shall-issue systems relatively quickly, adopting objective, standardized criteria for permits rather than the kind of subjective proper cause standard Bruen had struck down, following the roadmap Justice Kavanaugh's concurrence had essentially laid out: background checks, training requirements, and similar neutral criteria that any qualifying applicant could satisfy. Others, including New York itself, took a different approach, passing new laws that kept permitting requirements in place while dramatically expanding the list of sensitive places where carrying remained prohibited even with a valid permit, betting that restricting where a permit could be used would achieve similar practical effects to the old discretionary system without running into the same specific legal problem Bruen identified. The second segment is the wave of permitless carry legislation that accelerated significantly in the years following Bruen, even in states that weren't directly forced to change anything by the ruling itself. As of 2026, 29 states now allow residents to carry a concealed handgun without any permit at all, a movement sometimes called constitutional carry that existed before Bruen, but expanded meaningfully afterward, as state legislatures in gun-friendly states used the ruling's language and reasoning as political and legal momentum to eliminate permitting requirements entirely for people who are otherwise legally eligible to possess a firearm. Most of these states still offer an optional permit process, which remains genuinely useful specifically for reciprocity purposes when traveling to other states that recognize permits but don't extend the same courtesy to permitless carry alone. Meaning a resident of a permitless carry state who wants to carry while traveling elsewhere often still has good reason to obtain the optional permit, even though it's no longer legally required back home. The specific age threshold for permitless carry varies by state, with some setting the minimum at 21 and others allowing it at 18, reflecting ongoing, separate legal disputes about age-based firearm restrictions that Bruen's historical framework has also been applied to in the years since. The third segment is the sensitive places fight, which became one of the most heavily litigated and genuinely contentious areas of gun law in the years immediately following Bruen. The Bruen opinion itself acknowledged that certain sensitive locations, schools, government buildings, and legislative chambers among the examples the court mentioned have historically been subject to carry restrictions and remain constitutionally permissible to regulate even under the new historical test. Several states responded to Bruen's core holding on permitting by dramatically expanding their own definitions of what counts as a sensitive place, in some cases attempting to define such a broad swath of public and private space as sensitive transit systems, parks, entertainment venues, financial institutions, that critics argued the practical effect functionally recreated the same restrictive carry environment Bruen had just struck down, just through a different legal mechanism. New York's post-Bruen legislative response became one of the most closely watched examples of this strategy, expanding sensitive place restrictions to cover an unusually broad list of locations while simultaneously making Manhattan and other dense urban areas subject to a default presumption that private businesses prohibited carry unless they specifically posted otherwise. An approach that echoed, and in some ways anticipated, the exact kind of private property default rule the Supreme Court would eventually strike down in Hawaii's case years later. This tactic generated significant litigation of its own, with courts across the country reaching different conclusions about exactly how far a state's sensitive places designation could stretch before it crossed from a legitimate historical exception into an unconstitutional evasion of the ruling's core holding. A fight that in many respects previewed the exact kind of state versus court back and forth that would define this entire area of law for years afterward. The fourth segment is the moment the Supreme Court itself had to step back in to clarify its own test, because the inconsistency Justice Breyer's dissent had predicted turned out to be a real, serious problem within just 2 years. In 2024, in a case called United States versus Rahimi, involving a federal law disarming people subject to domestic violence restraining orders, the Supreme Court ruled 8-1 that the government doesn't need to find a historical twin, an identical law from centuries ago. Only a historical analog that is relevantly similar in both why it burdens the right and how much it burdens the right. This clarification became necessary because lower courts had split dramatically on how demanding the historical analog requirement actually was, with some courts striking down laws that seemed obviously reasonable, including the domestic violence restraining order law at issue in Rahimi itself, purely because no sufficiently identical historical twin existed from the founding era, a result that struck many observers as a troubling, almost absurd consequence of taking Bruen's language too literally. The fifth segment is the summer of 2026, when two major rulings landed within 1 week of each other and demonstrated just how far Bruen's reasoning continues to reach into genuinely different areas of gun policy. On June 18, 2026, in United States versus Rahimi, the Supreme Court ruled unanimously that a federal law banning firearm possession by unlawful drug users couldn't be applied to a Texas man based purely on his admission of regular marijuana use, without any additional evidence of impairment or dangerousness, applying the exact historical analog framework Bruen created to conclude the government's comparison to old habitual drunkard laws didn't hold up, since those historical laws targeted people who were practically incapacitated, not simply people who used a substance regularly. 1 week later, on June 25, 2026, in Woolford versus Lopez, the court ruled 6-3 that Hawaii's law requiring concealed carry permit holders to get explicit permission before carrying onto private property open to the public violated the Second Amendment, again applying Bruen's historical framework to conclude Hawaii's proposed historical analogs, including a law tied to Louisiana's Black Code, weren't relevantly similar enough to justify the modern restriction. Legal scholars observing both rulings noted they arrived within days of each other, and both leaned directly on Bruen's core methodology, one used to protect gun ownership rights for drug users. the other to protect carry rights on private property, showing the same historical framework continuing to produce significant, headline-generating results in genuinely different corners of gun policy 4 full years after the original ruling. One law professor who closely tracks the court's Second Amendment docket described the pattern emerging from these two rulings as evidence of a court showing what he called extreme skepticism about all manner of gun regulations, especially newer ones passed specifically in response to Bruen itself, a dynamic that makes it exceedingly difficult for state and federal legislatures to craft gun laws that can actually survive this now years-old but still evolving historical test. The sixth segment is what's still working its way through the courts right now, because Bruen's ripple effects haven't stopped, and several major questions remain genuinely unresolved. Legal challenges to federal restrictions on firearm possession by people convicted of nonviolent felonies have continued reaching the Supreme Court, and as recently as early 2026, the court denied review in a substantial batch of these cases, including petitions from individuals arguing their specific nonviolent felony convictions shouldn't permanently disqualify them from firearm ownership under Bruen's historical framework, leaving the underlying legal question unresolved for now while several other similar petitions remain pending before the court. Separately, litigation over age-based restrictions, specifically federal and state rules requiring a buyer to be 21 to purchase a handgun, has produced conflicting results in different federal circuits, with at least one major appeals court, the Fifth Circuit, ruling that federal law banning handgun sales to 18 to 20-year-olds is unconstitutional under Bruen, reasoning that the Second Amendment's text includes these younger adults among the people whose right to keep and bear arms is protected, and specifically noting they were historically part of the population enrolled in militias. The amendment was written to protect. While other courts have reached different conclusions on similar facts, exactly the kind of circuit split that typically signals the Supreme Court will eventually need to step in and resolve the disagreement nationally. The Supreme Court has also declined to hear certain age restriction cases as recently as this past summer, meaning this particular question remains unsettled and inconsistent, depending entirely on which part of the country you happen to live in, with some states and circuits currently allowing 18 to 20-year-olds to purchase handguns under this reasoning, while federal law and other jurisdictions continue enforcing the traditional age 21 threshold. The seventh segment is what all of this actually means if you're trying to understand your own rights today, in 2026, rather than trying to track every individual ruling as it happens. The single most important thing to understand is that Bruen didn't produce one clean, final, nationwide answer to gun rights questions. It produced an ongoing, actively evolving legal process that continues generating new rulings, new circuit splits, and new Supreme Court interventions on a rolling basis, 4 years in and still very much unresolved on several major fronts. If you own a firearm, carry regularly, or are simply trying to understand the legal landscape in your own state, treating your current understanding of the law as something that needs periodic updating, rather than a fixed, permanently settled body of knowledge, is genuinely the most accurate way to approach this entire area, given how much has continued shifting since 2022 and how much clearly remains in motion right now. Let's step back and name the single thread running through every single development covered in this timeline. Bruen didn't just decide a case, it created an entirely new methodology, a demand for historical analogs rather than modern policy balancing, and that methodology has been applied, tested, refined, and argued over continuously in the 4 years since, touching areas of gun policy that have nothing to do with each other on the surface. Permit systems, domestic violence restrictions, drug use, private property carry rules, felony disqualifications, age restrictions, all connected by the same underlying legal question the court answered back in June of 2022. Every one of those individual rulings, whatever specific outcome it reached, is really just another chapter in the same ongoing story that started with 2 men in New York being denied concealed carry permits because they couldn't articulate a specific enough reason for wanting one. It's worth appreciating just how unusual this level of sustained legal activity actually is, even by the standards of major constitutional rulings. Most landmark Supreme Court decisions settle an area of law for a meaningful stretch of time, providing lower courts and legislatures with a stable framework to work within for years before the next major case forces reconsideration. Bruen has behaved differently, generating an almost continuous stream of follow-on litigation, circuit splits, and Supreme Court interventions at a pace that has genuinely surprised even close observers of the court. Part of this reflects the sheer scope of what Bruen actually did, replacing an entire methodology rather than deciding one narrow question, which meant nearly every existing gun law in the country suddenly needed fresh litigation to determine whether it could survive the new test. Part of it reflects the genuine difficulty of the historical analog approach itself, an inquiry that, as Justice Breyer's dissent predicted, simply doesn't produce clean, predictable, consistent answers the way a more traditional balancing test might have, meaning nearly every new fact pattern generates fresh uncertainty rather than a straightforward application of settled precedent. If you take one thing away from this breakdown, let it be this. When you see a new gun rights ruling make headlines, whether it's expanding rights or restricting them, the actual story is rarely just about that one case. It's almost always the latest chapter in the story that started with Bruen, applying the same historical methodology to a new fact pattern, and understanding that connecting thread is what separates genuinely following this area of law from just reacting to isolated headlines as they happen to appear. 4 years in, with major questions still unresolved on nonviolent felon disqualifications, age restrictions, and likely several more categories of gun regulations still working their way toward the Supreme Court, this story isn't close to finished, and understanding the framework Bruen established is the only reliable way to make sense of whatever comes next. If this helped you understand the full arc connecting 4 years of gun rights news back to a single foundational case, share it with someone who's been trying to keep up with all of it without ever seeing how it connects. Subscribe so you catch the next chapter in this ongoing story the moment it happens, and I will see you in the next one.